Greetings of the day. I am Megha Gupta, an assistant professor in Babu Banarasi Das University. Today, I'll be teaching you the objectives, nature and definition of Niqah, in which we'll be dealing with the legal disabilities. This is part 2 of the series of Niqah. We've already dealt with the essential elements of a Niqah, of a valid Niqah rather, in the first part of the video, that is titled Niqah Part 1. In this, we'll be discussing the freedom from legal disability, which includes absolute prohibition, relative prohibition, and miscellaneous prohibitions. The first degree of prohibition is the absolute prohibition. That means marriages within these degrees is absolutely not allowed. A Muslim marriage cannot take place if the parties are within blood relationship or prohibited degrees of relationship of each other. Such marriages are void. This degree includes consanguinity, affinity, and fosterage. Consanguinity basically refers to blood relationship in which a man is barred from marrying the following females, namely his mother or grandmother, regardless of the generation. Second is daughter or granddaughter, regardless of the generation. Third is sister, full blood, half blood, uterine blood, doesn't matter. Fourth is niece or grandniece. Fifth is aunt or great aunt, whether paternal or maternal. A marriage with a woman who falls within these categories is void, and children born out of these marriages are considered as illegitimate. Now, after consanguinity, we come to affinity. Affinity is marriage with those certain relationships which have been named further, under which to whom you cannot get married under Muslim law. The prohibited relationships are as follows: wife's mother or grandmother, wife's daughter or granddaughter, father's wife or paternal grandfather's wife, his son's wife or son's wife or daughter's son's wife. A marriage with these women is prohibited under the degree of affinity. Now, after consanguinity, affinity, the third relationship is fosterage. Fosterage refers to milk relationship. That is, when a lady has breastfed a child or catered to a child within the first 2 years of his life, then that lady is called the foster mother of that child. A man is restricted from marrying the person to whom he has a foster relationship. The restrictions are as follows: his foster mother or grandmother, daughter of foster mother. Under Sunni law, there are certain exceptions to the following. Those are sister's foster mother, or foster sister's mother, or foster son's sister, or foster brother's sister. The Shia jurists consider consanguinity and fosterage at the same footing and deny the exceptions that are allowed by the Sunnis. After absolute prohibitions comes relative prohibitions. Marriage which take place under relative prohibition are not void but only regular, and they can be considered valid as soon as the irregularities are removed. Relative prohibitions are as follows: unlawful conjunction, polygamy, absence of proper witnesses, difference of religion, marriages during iddat period. Under unlawful conjunction, a Muslim man is prohibited from marrying two different women if they are related to each other by means of consanguinity, affinity, or fosterage. As if they would have been of opposite sexes, their marriage would have been void or batil. After the termination of marriage or death of his wife, marriage can take place with the other. Under Sunni law, marriage in violation of unlawful conjunction is fasid and not void. But under Shia law, the marriage violating the rule of unlawful conjunctions is batil. Polygamy. The term polygamy refers to a man with more than one wife. While Hindus do not allow polygamy, Muslims are allowed polygamy up to 4 wives at a time. But if he marries the 5th one, despite having 4 wives, the marriage turns into irregular but not void. The 5th marriage can be valid after the death or termination of marriage of one of the 4 wives. However, the Shia law considers marriage with the 5th wife as void. In India, a Muslim marriage cannot have a second wife if the marriage is registered under the Special Marriage Act of 1954. Absence of proper witnesses. Under Shia law, presence of witnesses is not essential and marriage without witnesses is considered as valid. How if the parties are major or by their guardians if they are minors. Under Sunni law, presence of witnesses is essential, or else the marriage is considered to be irregular. At least 2 male or 1 male and 2 female witnesses should be present, and the witnesses should be major, of sound mind, and a Muslim. Difference of religion. Under the Sunni law, a Muslim man is allowed to marry a female who shows respect for same scriptures, such as Christians, Parsis, and Jews. That is, these people are considered as Kitabiya. But if he marries an idol or fire worshipper, the same is considered to be irregular. A Muslim woman is not allowed to marry a non-Muslim man, and if it happens, the same is considered as irregular. Under Shia law, a marriage with non-Muslim is considered as void. According to Faizi, such marriage is void, but according to Mullah, such marriage is irregular, that is batil. Marriage during Iddat. Iddat is a period of waiting after the death of the husband or after termination of marriage, during which she cannot remarry. The purpose of Iddat is to check whether the woman is pregnant and to clear any doubts of the child's paternity. A divorced woman has to observe Iddat period of 3 months, whereas a widow has to observe it for 4 lunar months and 10 days after the death of her husband. If the woman is pregnant, then it extends up to her delivery. Under Sunni law, marriage during Iddat is considered as irregular, whereas under Shia law, it is considered as void. Now, after absolute prohibitions and relative prohibitions comes miscellaneous prohibitions. Marriages done during pilgrimage are considered as void in Shia marriage. Remarriage between divorced couple is considered as void. A certain procedure needs to be followed in which a Muslim lady has to perform a valid marriage with another man. Then only her husband will voluntarily divorce her, and then the lady needs to perform iddat. And after all of this is done, then only she can marry her previous husband. If this procedure is not followed, the marriage is considered as irregular. Third is polyandry. It refers to a condition in which a woman has more than one husband. Islam does not provide for polyandry. In the case of M. Jainoon versus Amanullah Khan, Madras High Court observed that although registration of marriage is not necessary, it cannot be said that registration of marriages is prohibited under Muslim personal law. That's all under the topic of legal disabilities in a valid nikah. Thank you.